as is a long standard pattern in all of these cases with MPS and yourself, that there is now more evidence of bias. And what we have here is a blatant attempt to not have this hearing just like we did for Dr. Kuether. What we've got here is bias by this tribunal here that frankly is doing the work once again of the employer MPS here, and is not acting as a neutral tribunal by any stretch of the imagination. That's what happened when you were selected for this case to beginning, when this the media case for Dr. Kuether, the email that went around when Judge Alice DeLeo conferred with Matt White about staying this case, Dr. Kuether's case. This also happened when you made several, this is you, Judge Brown, that we're talking about, made several rulings specifically on Dr. Garcia-Hoven's case that limited discovery, that limited the ability of Dr. Kuether to organize and work with Dr. Garcia, that limited Dr. Garcia's ability to work with Dr. Kuether, that limited Dr. Garcia's ability to work with Dr. Ford, that limited Dr. Ford's ability to work with Dr. Kuether, that limited Dr. Kuether's ability to work with Teresa Falderon and other MPS complainants. That was done, the tribunal gave them a 30-day stay without any action on their part, without any basis, without there being an ALJ in there. There was an ALJ, it just turned out it was a secret ALJ, Alice DeLao. That is going to be a continuing theme here and what we're going to discuss here, because as we know, Judge, you have been secretly just conferring on this case with Alice DeLao, and that she has been participating in making decisions on this case with yourself. You have not acknowledged that fact, but we have been able to show that through public records. It is quite clear here that we're not getting actually, this is also true, that Maria Salsor has been part of this continue of prejudice against the employees who are seeking redress from MPS. Now, I know that the ERD looked bad because of the 30-day stay in the media email. I know the ERD didn't like having Dr. Garcia-Hoven's case in the media. I know that you particularly didn't like having your name in the media, or for example, when I put out an email to WELA, how then you responded within hours on these related cases. You didn't respond for months before that, but the moment I put something out on WELA mentioning how the mediation style and how these things happen, then of course there's an adverse decision with, again, no basis. That was similar to when we asked you to recuse yourself. There was just no basis. Well, if we're going to have a tribunal that can't follow any kind of law, that just makes things up as they go along, and secretly acting behind the scenes. And let's also be clear, because we got to get this one out there too. Why is it that Dr. Garcia-Hoven's second ERD claim is been unable to progress get a determination for now 14 months? I wonder why that is. We have asked that investigator now for a year. She has told us, I think 8 times, that we would have it somewhere between a week or 10 days. That hasn't happened. We've called her up and said, can we get public records? Would that identify why we're not getting this case? We've talked to Matt White, who said we'll have it within the end of the week. We've talked to Jesus Villa, who said we'd have it. We've had to reach out to him on social media, my client did, to get why can't it get consolidated? Why is it that seemingly any other case that's assigned to this investigator can get a determination, but not Dr. Garcia-Hoven's determinations? Why is that? I think we're all pretty clear on what the answer is here, and because apparently it's common sense that those two things can't be connected, aren't we? And that, I think, is just another line through here on more prejudice, more unfairness, more, again, handmaiden of the ERD for MPS. It is becoming increasingly clear that the ERD is not fit for the purpose of handling discrimination cases against Milwaukee Public Schools, and that another forum needs to be dealt with here. Again, I refer back to this is Stephanie Brown's letter accusing this is says it almost all, confidentiality. That for somehow Dr. Ford and Dr. Garcia-Hoven can't talk to each other about each other's cases. Because as we know, even though we've had so many attempts here by MPS and the tribunal to keep this information from us, Matt Chasen testified just 3 days ago and was very clear that there's an absolute through line through Garcia-Hoven, through Dr. Kuether, through Dr. Ford. And that through line is Dr. Holliday. And it's very clear that not only did you know that, going back to when we had the first pre-hearing, and then out of nowhere, did this tribunal decide that we couldn't discover anything about Dr. Holliday. So we had to have farce after farce after farce of depositions, where first we had Yashika Spears. Now, Mr. Reardon rage quit from that one. You took no action, of course. And closed that down, just yanked the court out. Why? Because we were asking questions that he thought. We discovered the fact that he had told the witness that any discussions of anything that happened before 300 days, she was not to answer. We brought that to your attention, you did nothing. Right, so we didn't, and when we found that out, what happened, then he rage quit and closed off the deposition. We have still yet to have a chance to depose her. You did nothing. Then we go and try in this farce of Matt Chasen. It probably took us 5 months to get Matt Chasen to be deposed in this case or in any other case. Because they kept claiming third-party witness, they kept claiming that they represented him, they kept claiming, again, 10 months. And Dr. Garcia-Hoven's fees are being racked up, you know this. They're paying for all of this, and yet they're just goofing around, pretending like they don't know what the law is. Now, you ordered back in December that they produce Matt Chasen's documents. What did they produce? They produced some documents and then they blacked out things because they said they weren't relevant. Now, despite the fact that you already was clear on what relevant was and what it isn't, and despite the fact that they know what a protective order was, you did nothing. You did nothing. You pretended like you didn't have an argument. You ignored our argument, and then you pretended like that put no obligation on you to either do any analysis on what they did. So you didn't. You just sat there and you said, well, you didn't respond in time, so hey, I get to make up whatever decision, they win 100%. Judge, the definition of judge is to apply the law to facts. If you just automatically rule in MPS's favor, that's not even meeting the minimum definition of what it is to be a judge. That's problematic, and it shows bias. We also, again, the timing of all of these decisions. Let's go back to July 15th. What happened then? Well, Dr. Kuether attempted to view Dr. Garcia-Hoven's pre-hearing. So instead of having members of the public at the pre-hearing, you canceled it. And the paper trail is there. We laid it all out in detail for you for over 5 pages, and how did you respond? You didn't. That doesn't meet the minimum definition of judge either. When you are confronted with facts that don't agree with your preconceived notions, it's not enough to simply ignore them. They have to be addressed, and they have to be dealt with. When you don't do that, there's no evidence of sifting or winnowing. We brought that to your attention as well. You didn't respond on that issue. Once again, the only analysis I think that we've had in this case so far is whether or not Dr. Holliday is relevant. The legal justification for that is that it's common sense. The second decision that we've had in this case is that for some reason, because Dr. Kuether personally assisted in serving Matt Chasen, that she is not allowed to go to a deposition involving Matt Chasen. That didn't make any sense either. But nevertheless, the decision there was, hey, and let's be clear how the progression of that went, because I think it shows here what's going on. The first decision was that nobody can go to anybody outside. I can't have any assistant to a discovery issue involving MPS. But really that meant Dr. Kuether, and we all knew it. And when you got called out on it to the secretary, then you justified why it meant Dr. Kuether, and only then. And see, that's what shows, and of course there's a lot of discourse between you and Alice DeLau between all of that, but that there is what shows that had you been clear from the beginning that your purpose was to exclude Dr. Kuether, then you could have at least underpinned that with some kind of reasoning. The fact that you didn't underpin it with any reasoning whatsoever until after you were called out on it, not just first, but then ultimately to the secretary, and wrote it to the secretary to defend yourself and justified it that way, that makes it clear to me that nobody identified Dr. Kuether except for you. So it went from nobody can assist me to only Dr. Kuether. And again, the reasoning was nothing other than she assisted something that everybody has a right to do, which is to go serve somebody. Which is so parallel to this situation that I'll underscore it here. Again, there was no basis in fact to do what you did. But so you came to this predetermined conclusion, and then you went to the aid of Milwaukee Public Schools and said, no, Dr. Kuether can't come without any evidence. The same thing with Dr. Holliday cannot be, is not relevant to this case. You did so without any evidence. Now you're demanding that my client, who we've represented to you, is ill, and you're putting a deadline on me because I guess you've been inconvenienced here. But again, my client is the one who is suffering from COVID. And we're now supposed to go and produce documents to you for their benefit.
It's for my benefit.
No, it's for their benefit. Nobody has ever they have made an accusation. They have not backed it up with any evidence. You're then going to get evidence here to back up your preconceived conclusion, which is once again evidence of bias. And this line is through all these points, meaning there is no curve, it's the same behavior. And that's why we're calling it out. We're calling it out for July 15th. We're calling it out for the 30-day stay. We're calling it out for the fact that you have been assigned to all of these cases. We're calling it out for the fact that we can't get an ID on the second case no matter what. And that's clearly not happening by accident, we all know it. We're calling it out for what happened against Dr. Kuether. We're calling it out for your obvious termination of a hearing, denial of our opportunity to be heard, so that you could not have to be confronted with Dr. Kuether. So that she, for some reason, and again, you stated this and you put it in writing, you do not want employees working together. You stated that. You fear that that's a violation of the Supreme Court rules. You also put in there that it's a violation of Supreme Court rules that I represented Dr. Ford and Dr. Garcia-Hoven at the same time. You're the one who put that word adverse in there. And of course, they picked up on it, and so did an independent body. Now, again, they were able to clearly see what the law was. Again, we're not talking about insurance law. We're not talking about maritime law. We're talking about the Wisconsin Fair Employment Act, which is your job to enforce. And yet an independent body took some minutes to determine what the actual law was. And once again, that Dr. Garcia-Hoven, employees cannot be adverse to each other in the ERD. And you know that. And you knew that when we told it to you the first time. You knew it when we asked you to recuse yourself for bias. You knew that. You still know it now. And if you don't know it, it's a bigger problem. Because you are supposed to be the one who is judging whether or not the employers have violated the Wisconsin Fair Employment Act. But instead of possibly investigating those LERT decisions there, you published a letter stating that I was acting unethical because I represented both Dr. Garcia-Hoven and Dr. Garcia-Ford. You didn't know whether or not, you said it might be. And you were also very clear that you had a problem with confidentiality, meaning two employees working together to try to benefit themselves and to try to work on against discrimination here in Wisconsin, something that the ERD is empowered and mandated to do. Mandated. Now, we're not asking, I guess what we're asking is fairness. We're asking for an unbiased decision maker. We're asking for someone who doesn't go out of their way to try to punish or get the employee. We're asking for somebody who is not acting on behalf, trying to exclude Dr. Holliday on the basis, again, of common sense. Yeah, we have that quote, Judge. We've got it. It's in the transcript. You said that Dr. Holliday was being excluded because it was common sense. That's not a law. There is no such thing as the law of common sense. There is a Wisconsin Rules of Evidence that we have. That trumps common sense. But putting the Wisconsin Rules of Evidence in front of you didn't seem to matter, because it seems like excluding Dr. Holliday was a primary concern. That the law was a secondary afterthought, that's why it couldn't be cited to. The same thing, the justification for excluding Dr. Kuether was an afterthought. And you know, Dr. Kuether is suffering here, and I want to be clear on that. So are all of these employees. They're paying. They're not being paid to be here like Adria. They're not being paid to be here like these two gentlemen. They're paying with their blood, literally, Judge. Now, I know you all know that because I hear Judge DeLao tell employees that when she's pressuring them to settle their cases prior to here. She goes over how difficult it is to prevail, how seldom that, we've got the emails here from you all talking to each other about how great it is when somebody finally prevails in front of the ERD because it happens so rarely. We've got those. Just like we have the response from the Equal Rights Division saying that they will not give us emails between you and Judge DeLao regarding this case because they are deliberations. Now, I don't know what judge I'll put it another way. I know exactly what judge we thought we drew in this case. And draw, by the way, is a misnomer here because it's nothing like a random selection here in the Equal Rights Division, which we know. It is a policy choice that to make you the judge in this case. It's a policy choice to make you the judge in Dr. Kuether's case. It's a policy choice that Judge Benitez Morgan is now going to be the judge for the Ford case. That's a policy choice. And we all know that that was discussed. Because again, it's not happening randomly. These things are happening on purpose. And we've got the evidence to show that. Now the problem with all that is that the evidence doesn't seem to matter, because just like when we put the law in front of you regarding what's that Dr. Ford and Dr. Garcia-Hoven cannot be inverse, that did nothing. You know what you did? You said, I'm not taking the letter out because I don't see anything wrong with it. That's what you said. I'm not taking the letter out, there's nothing wrong with it. Well, the independent body thought there was something wrong with it. They sure did. And again, for them to come to that conclusion only means one thing. That either you know that they can't be adverse and you wrote that, or you don't know. Either way, it's the same problem. And you know it. And we know it. And so when we put all of this information, and I think it was 20 pages, 30 pages,
Yes.
I think we spent a month, instead of deposing Bob Peterson, instead of deposing Superintendent Posley, which you know about. You knew about all of those witnesses left to go. You saw our matrix. You knew that they had delayed. You knew that they had refused time and time again. We sent them notices. They just pretended like they didn't get them. They said we didn't fax them. On and on and on we went. So instead of doing that discovery, we responded to the fact that you were biased in this case. And we spent a month on it. Again, while being peppered with, I think, frivolous motions from them, aided by you. For example, their motion to have me excluded from the case based on your letter. Right? And so again, the reason that's frivolous is because they, being attorneys, and signed their name to a document saying that it was unethical for me to represent Dr. Garcia-Hoven and Dr. Ford at the same time. Well, they had a duty to look it up. They didn't do that. You didn't review the issue. You didn't at all. You just said the ERD is not going to respond to an accusation of misconduct. Which is what you did. That's how you got out of our issues as well. Whenever we raised their misconduct, you just said we're not going to deal with it. Okay, well, then Dr. Kuether gets assaulted. Then he goes up and calls her a coward in my office. Nola Hitchcock Cross had to get up there and remonstrate with these fellows. She had to stop what she was doing in her day, listen to this woman, and how he called her a coward. She had to stop what she was doing, go up there, and remind him about how he had already done this once before. How he had already contacted one of my clients, Dr. Ford, and said about 3 different stories about what it is and why he was contacting her. We put those all in front of you, and you declined to do anything about it. So we did it again. You had the authority then, but you declined. So we did it again. And that's a pattern here that not only is there one set of treatment for MPS and another set of treatment for the employees, but also when there's no corrective action of any kind taken with their flagrant abuse of the process, then they only do it again and they do it more. And we warned you back then, we warned you now, and it's still, what do we have? You need to stop what you're doing. You have to, by the end of the day, have to go find out what your client's ill. No problem, I don't care. He might be dying, that's totally irrelevant to me. By the end of the day, I want you to tell me what his travel plans were. because they made an accusation saying that he was not planning on being here. You have no evidence at all, and you know it. What you have, and she admitted it, she has no evidence. She has hearsay of where he's supposed to be. And now you are going on a fishing expedition to try to find out if you can exclude his testimony here. That's what's happening. And that's why I'm sitting here talking all about it, because I think everybody in Wisconsin needs to know that that's what's happening here. That the Equal Rights Division is going out of its way to prejudice Dr. Garcia-Hoven. They did it with Dr. Kuether. I guess the other complainants who come to the ERD shouldn't be surprised if they do it to them. Because that is the systematic problem here that we're trying to address, and that we have been unable to address. When you go to the Equal Rights Division, apparently against MPS, there is a completely different set of rules. Now again, the law is out the door, but then again there's a secret bureaucracy set of rules that nobody tells you about. Certainly nobody told me that we wouldn't be able to get a decision on Dr. Garcia-Hoven's second case for anything. Nobody told me that the moment we withdraw Dr. Kuether's case, lo and behold, we get 2 probable causes within a week on MPS cases. I wonder if that's by accident. Because based on my training and experience, I would say that those 2 events took place too close together. It certainly doesn't have the appearance of anything other than one thing was a prerequisite for the other. Meaning those cases were never going to come, get their ID until Dr. Kuether got out of the ERD. We also have that here. Do you know how many times this gentleman, who should be sitting next to me today except he's ill, has written to Letitia Daly to ask her for his probable cause determination one way or the other? And that's the one judge that's really clear that Saffold and Holliday are just going after him. But it's common sense that we can't get those in here. It's common sense that we can't consolidate them. Well, it seems to be kind of ERD sense to me, because that's the only place I've heard that kind of logic. I've certainly never heard it in court. There is absolutely nothing in the rules of evidence, and in fact it's just the opposite when you get to relevance, that Dr. Holliday should have been excluded from this case. And you didn't just exclude him at the hearing because you found out at the hearing that he was relevant. You excluded him at the pre-hearing before 1 single ounce of discovery had been taking place, which is expressly against all the cases that we showed you. And you know, I'm all for personal growth. But when we look at the tape video, for example, and we look at that one on YouTube, it's really clear that there's a separate set of decisions with regards to relevance and Bowen and Brown, because you turn to City Attorney Catherine Headley and tell her that we are not to exclude things for relevance. It's on tape, Judge. I'd be happy to send you the link. You can all go to YouTube and watch it. I'd appreciate the views. But you just compare that statement in there to it's just common sense, and the one statement was based on the law, the other statement wasn't. But through all that, how many times have I talked about Brown? Again, a personal hero of mine, God bless that man. Because how many times did he get denied? How many times did the ERD shut him down? And almost 3 times did he have to go against Alice DeLau and Judge Schock, just throwing him out nearly sua sponte. And for all the viewers, that means on their own initiative. And so when we look at that and say those two things are incongruous, then we look at, okay, who's the respondent? Well, in Tate, the respondent was NPS. But here, what's different? It's Dr. Holliday. That's the through line there. It's Dr. Holliday. And I will be very clear that apparently there's one rule for all these set of cases when Dr. Kuether's involved, the media case. And anybody else who touches Dr. Kuether, as far as the ERD is concerned, it seems to me that there is a secret policy that any case that's associated with Dr. Kuether gets treated differently. And I think that the evidence, again, has shown that. So when we start out here, we go decision, the 30-day stay, the pre-hearing exclusion of Dr. Holliday, the exclusion of Dr. Kuether. And I guess I'll need to incorporate by reference my original motion, and we'll get it here in the record too, my motion to have you recuse yourself, and also your response on that. Because as I said, we went point by point by point through all of these legal issues, and we did not get a response on the law on any of those issues. The response to the motion to recuse yourself is only evidence of more bias. Because again, it shows, just like with Dr. Holliday, that you made that decision before you heard any evidence. And that's what Brown and that's what Bowen stand for, that you can't do that. But hey, you told us, because this part of the law you were really clear on. What's our remedy? Our remedy is to go through this hearing and go to Lurk and to have Lurk to have Lurk decide. Right. And that's another one. Calvin Furman. When the decision on Calvin Furman came out? The day after it was in the news. We waited 3 months on that one. We asked you for a response on that one. But once again, media is driving these cases. And let me be, I would be remiss if I left out, once again, this is Ben Hitchcock Cross speaking here, made a free speech comment and showed colleagues on the Wisconsin Employment Lawyer Association list about emails that we had received from public records from you and others. Based on the metadata in the PDFs, you were working on that response within 2 hours of me sending that email out. That's a pattern that we have noticed, again, with the July 15th Maria Selsor response. We also noticed that again with the when we went to the secretary about excluding Dr. Kuether from Dr. Garcia-Hoven's hearing, that you then, when you look at the metadata on those decisions as well, that once again, free speech equals, let's say, prejudicial decisions. Then we go on to, there is an email about these cases between Jesus Villa and Matt White. The department will not give it to us because they claim attorney-client privilege regarding Dr. Garcia-Hoven and Dr. Kuether's cases. So I want that to sink into everybody, that the Wisconsin department of Workforce Development is claiming that conversations between an administrator, that's the head of the ERD at that time, Jesus Villa, and the head of the investigation section, and that's the person, the direct supervisor of Letitia Daly, who has not provided a determination in almost 14 months on Dr. Garcia-Hoven's second claim. We note that they claimed that the conversation between the two of them, they blacked it out, and they refused to produce it to us on the grounds of attorney-client privilege. As if Dr. Garcia-Hoven and Dr. Kuether are adverse to the ERD. And believe me, we get that sense by the way that the ERD behaves, that the ERD feels that it is adverse to Dr. Garcia-Hoven and Dr. Kuether. I also note that some little time after that decision, Jesus Villa announced that he was moving to other, possibly greener pastures within the state, and that he is no longer the administrator of the ERD. That privileged communication between Jesus Villa and Matt White referenced Dr. Kuether's case specifically, because apparently there is a secret policy for cases that get in front of the media, just like this one here. And we note that the moment Dr. Garcia-Hoven's case was in front on Channel 4 News, that the ERD's response to his case, and apparently his opportunity to get justice, was set on a separate track. And it's that kind of tracking that we really need to identify here, because they use that in education. They use it for trainings. And the concept here should be that all employees have the same right to get to the same station, the same endpoint. That there's not two tracks or more. Because what happens is, if the ERD is not able to cite the law, to not retaliate against people for their free speech activities, to fairly apply facts, to not act on behalf of the employer, then the only forum left to employees is the federal court. Which that may be the goal here, I don't know. But that is something that Mr. Reardon will have to keep in mind, I guess, because here we are at the Equal Rights Division, and we've spent thousands and thousands of dollars. We're spending $1,000 here today, and what we have to show for it is prejudice on no basis whatsoever for somebody saying that they have COVID. Another burden, once again, placed on the employee because he has fallen victim. And doesn't that just say it all? Doesn't that just say it all? The man is sick here. They come in on absolutely no evidence whatsoever, and the most they can say is hearsay that he went to Columbia, and your first thing is to do what they've asked. And again, let's be clear, because the record will show this. You wanted to get his flight records before you had even evidence from them at all. Bowen and Brown all over again. That is a priori here. And for the viewers, that means before the fact. So, Brown again and Bowen both stand for this proposition that ALJs are not to make decisions on evidence before the fact. And that's what's happened here today. That's what's happening with Holiday and so forth. And again, when we put that in front of you, you were very clear that you know that our only remedy, and I want to again juxtapose your knowledge of that aspect of WEFA as opposed to the aspect of WEFA that says that two employees can't be adverse to each other. But you know that our remedy here is to have the full hearing and complain to Lurk in some 8 months from now. You've told us that straight out. Now,
Okay, can we take a break? The court reporter said she needs a break.
no problem.
You can go off the record.
Please.